Hi, my name is Frank Ramos, and today we're going to be talking about the associate's life. As a young attorney, it is difficult to start this new chapter in your life. It's very different than what we were accustomed to in law school. It's often said that we don't learn how to practice or how to be a lawyer in law school, and that comes from your first job and from a lot of experience and a lot of time in the office, in depositions, and in the courtroom. And today we're going to talk about a number of things that you can do to improve your role at your firm and to become the best associate and young lawyer you can be. When you start at a new firm, either right out of law school or as a lateral or just as a young attorney, really get to know the firm. Come to know what the firm is about. Visit their website, read their mission statement, their vision statement, read their values and their core principles, and get to know who they are. These are their North Star. This is what directs the firm, drives the firm, and dictates what the firm is all about. And in order for you to succeed and thrive at the firm, you need to know what the firm is about. So when you first got the job, you probably looked at the website. You may not have looked at it in a while. When you start up there again, look at it. Make a point once a year, if not more, to sit down and study the firm's values, the mission, and vision. I've been an attorney now 23 years. I've been at the same firm for 22 of those years. And every year I sit down and look at our website very carefully, and I study our mission, our vision, our values, because those are who we are. In addition to knowing generally about the firm, you need to know about the individual partners and associates who work there. No two attorneys practice law the same way. Each of us have our own idiosyncrasies. Each of us have our own approaches, pet peeves, and do's and don'ts. And whomever you're working for has their own set of doing things their own way. So take the time to learn how your firm does things and learn how your supervising attorney or attorneys handle things. Speak with other associates who work with him or her. You may want to consider taking them out to lunch or for coffee and learning what they like and what they don't. And again, each of us handles the practice very differently. Each of us uh, have different contents for how we want our motions or memos in the office, how we want to argue a motion or take a deposition. There are some basic skills, and we'll be going through some of those. But again, understand the proclivities and what your specific supervising attorney wants. If you can get on their same page and give them what they want on their terms, that will make your relationship with them be much smoother, much better, and go much more swimmingly. And there's an issue also of understanding how your office works. Each office has its own mode of operations. They have their own protocols. Your specific office may have a series of checklists on how to handle specific aspects of cases or clients or office procedures. Get to know those. Some of these are written, some of them are not, some of them are understood. Really try to understand how your law firm operates, especially how your department operates or your practice group, and specifically the individuals you'll be working for and with. And just as important to get to know the partners and how they operate, you need to get to know the other associates. Again, each of us have our own way of doing things. Each of us have things we like and we don't, and certain things get on our nerves, and some things we really enjoy. And so really observe the other folks at your office, really study them and take the time to get to know them and understand them and speak to them on their terms. Now, ideally, if your firm is really interested in maintaining and keeping their associates, they're doing the same. They are conducting surveys, or they're asking informally among their young lawyers what they want, what they like, what their interests are, what their purpose and passions are, in order to keep them engaged and keep them involved in the firm. So hopefully the firm is doing that for you and keeping you involved, and it is up to you to do the same for the firm. You want to make sure that you are sort of swimming along with them, and moving the oars in conjunction with everybody else, so that you are adding to the firm culture and not detracting from it. And so much of what happens in a firm is communication. You have to understand and come to learn what your boss and what your clients want in terms of communication, how often they want to be communicated with, in what manner they want to be communicated with, and about what they want to be communicated with in terms of just what's going on. At some point, you're going to be handling your caseload under the supervision of one or more lawyers. And depending on the type of cases you're handling, it may only be a handful of cases or maybe dozens or more. Some associates I know handle 50, 60, even 80 cases in their firms, whereas some only handle a few because they're much larger and much more complex. So you need to know how often you need to report to your partner, what you need to keep her apprised of, and what the client wants, what she wants in terms of reporting. And usually most clients have reporting requirements. They'll spell out what they expect, what they want to be told about, what decisions they have to make versus you, how much discretion or control you have over your cases versus them, and certainly partners are the same way. Once you start your firm, what you'll find is most partners will kind of keep a close eye on what you're doing. And once they see that you're capable of handling the matters on your own and making your own decisions and making wise ones, they'll give you more discretion and more liberties and give you a wider berth in how you handle your matters. So the first thing is to earn the trust and following of those above you. And that comes down to making wise decisions. And so there's certain decisions you'll be able to make, and there are ones that you're going to need help for. And my rule of thumb is if you're not really sure, ask someone. You can always ask another associate. You can always ask a partner, obviously, but don't do something that you're not positive about, or at least mostly certain about. And even then, sometimes we make mistakes. There's sometimes I make decisions that I wholeheartedly believe are the right ones and turned out not to be the best decisions in our case. That happens. And understand that the process of becoming a lawyer is a long and arduous process. It's fun, it's challenging, it's rewarding, but it is tough. And you will make your fair share of mistakes along the way. You will stumble and you will fall, and you have to learn to get back up. You need to learn from your mistakes and move forward and move on. And nobody really likes to hear that. Many of you, I'm sure, did quite well in high school and college and law school, passed the bar, have a large set of accolades and rewards and certificates and diplomas. And that's great, that's wonderful. But practicing law is a whole other ballgame, and it is very different. And you will stub your toe and you will make mistakes. And the best advice I have for you is always think through any issue you have. Really think through until you have a solution or solutions. And think through if it is a positive and effective solution. And if you're still not sure, go to your supervising attorney and ask her, this is the issue, this is my proposed solution, what do you think? And get their feedback. And it is much easier to deal with something before you do it than afterward. Try not to make a mistake that will cause problems for you or your firm. And a good way of avoiding mistakes is by making sure you speak up and talk things through before making weighty decisions. For example, you may have to make a decision about what a client expectations is about the valuation of a case, about the credibility of a witness, about the outcome of a matter. These are sort of big picture items that you may not feel comfortable opining on. And those are the sort of decisions you really need to bring in a supervising attorney. And this sort of brings us to another issue about client communications. At first, your firm may not allow you or give you much leeway in communicating with clients, and they're protecting both you and the firm because they don't want you to say something inadvertent that undermines your credibility or the firm's credibility. But sooner than later, you'll probably start emailing and speaking with clients. And it's very important that you are careful what you communicate with them. You don't overpromise and you don't underdeliver. You don't make representations about the valuation of the case as a certainty, for example. No one knows how any case will come out. No one knows what will happen in a given case, how a specific judge may rule, or how a witness may testify until it happens. And so to make representations that are basically predictions and strong ones, it's not really a good approach. It's certainly not something I recommend for young lawyers. Even at my vintage, at about 23 years out, I do my fair share of hedging. I spell out what the various resolutions or outcomes may be. I give my thoughts as to why one outcome is more likely than the other, but at the end of the day, I certainly don't guarantee or suggest that I know what's going to happen. No one does. We don't have crystal balls. We can't predict the future in any of our matters, as much as our clients want us to. Sometimes clients just want some reassurance. They just want someone to listen to. They just want an ear. Sometimes cases are bad. They have potential large exposure. They may have bad publicity for the company, may adversely affect the stock or reputation or brand of the company. These are all tough situations. And part of our job is not just being an attorney or even a counselor. Sometimes it's just being an ear. Sometimes bordering on being a therapist. But at the end of the day, it's important not to make predictions, hard predictions. And sometimes clients will lean hard on you for those, and you really need to bring in folks above you in your firm's pay grade. And so what's so important in any case when it comes to communicating with the client is that you need to find out from them what they want to be made aware of and what decisions they need input on. Typically, if you have to spend money on anything, they're going to want to have input. If you need to hire an expert, they're going to want to have input. If you need to draft a major motion that will require lots of time, which they will have to pay you for, they will need input. The daily things we do in a case, like sending out subpoenas or sending out written discovery, probably not so much, but bigger picture things, certainly. And a good thing that I do, and what I recommend that you do early on in the case, is to do a full case evaluation. And what that means basically is that when you first get a case, and I'm talking about defense lawyers, because this is directed primarily to defense lawyers, but also works for plaintiffs lawyers as well, is that you find out everything you can about the case. And you get all the documents you can, first from your client, and you make sure the client understands that they have to be forthcoming, open, and transparent with you. Sometimes clients have smoking guns and they're ashamed or embarrassed to turn them over, and that's the worst situation for everybody. I need to know, and you need to know early on, what the case is about, good and bad, anything that happens or is related to the case, I need to know about it. It's much easier to deal with a case if I know all the facts, especially the bad ones early on, than it is to be surprised by them in deposition or at a hearing, and certainly at trial. And so first and foremost, get everything you can from the client. Make sure they preserve all their documents. Make sure that you send them a preservation letter to confirm that they're doing what they can to preserve electronic discovery and data. And then sit down and talk to all the witnesses you can. Certainly talk to your client and get a full understanding of his or her perspective of the case and the facts giving rise to the case. Talk to any witness you can that you're entitled to under the law, under the rules of ethics. Sometimes you can't talk to witnesses. Some of them are represented, some of them are employed by other parties. Some of them just don't want to cooperate. But if there's a witness you can talk to him or her. Find out what they have to say. If it's favorable, preserve it some way. I'm not suggesting a deposition necessarily, but record the conversation, take a videographer with you, take a court reporter, take a sworn statement, do what you can to keep that testimony favorable. Sometimes a witness gives you favorable testimony, another lawyer comes along or investigator, they kind of plant ideas in their head, and when you depose them, you're expecting them to say X and they say Y, just the exact opposite. But if you have a recorded statement from them that you can impeach them with, then they're more likely to sort of stick with their original story that may have been very favorable to you. And so once you have all the information, once you've spoken with the witnesses and procured the documents, look at the law and look at all that information through the prism of the law. What are the applicable statutes, regulations, and cases? And what do they say about these set of circumstances, both these facts and these issues that you've come together? And think that through. And then do sort of evaluation of the parties involved. Determine what your judge is like, determine opposing counsel, determine the parties themselves, determine the veneer, doing jury verdict searches. This is all, by the way, a lot of work, a lot of time, which you need client approval. But I strongly recommend that you do get it, and obviously something you want to talk to your supervising attorney about. But doing an early case assessment, the earlier the better, really sort of puts you in the driver's seat. You really know what's going on in your case, and you know what the X factor is. It's a term I like to use, which basically means what we don't know about a case. And you want to make the X factor as small as possible. You want to make sure that you talk to as many witnesses as you can. You secured all the relevant documents. You determined what all the legal issues are and how they fall in your case. And the more you know, the better you can properly evaluate the case. Most lawyers, I think, most reasonable ones, will probably reach similar conclusion and valuation if they have the same set of facts and circumstances and they understand the law equally. And I think most cases settle when attorneys on both sides are honest and have a reasonable understanding what the case is about. And the only way you can do that is to have as many facts and have greater or greatest appreciation of the law that you can. And the reason for that is that you can tell your client, look, this is a good or bad case, a great or terrible case, and these are the reasons why. And on the defense side, one of the things you may have to do is see if you can settle early. You may have uncovered some really bad evidence, the smoking gun, let's say, that if it ever came to light through a request for production or a deposition, you'd end up paying 2 or 3 times more than what you're hoping to settle the case for. And so that's why it's important. One of the things we do as lawyers, we kind of overlook and forget, is that we're kind of like private investigators. We're out there and we're trying to research everything there is about a case, trying to learn everything there is about what happened. And it's fun. I enjoy that part of the case, sort of getting down and really figuring out how did an accident happen? Why did a contract get breached? Why happened around specific circumstances in this employment situation? And if you're honest with yourself and you have a serious evaluation of the fact and the law, you can then go to the client and say, look, this is my initial report to you. Things will change. Circumstances may change. We haven't been able to talk to A, B, and C, and there's still documents X, Y, Z we need to procure. But based on what we have and what we know, we can tell you this. And then you tell them the good and the bad and the ugly, and you explain to them what the situation is, and you hold up the facts to the light of the law, and you let them see through that prism what case they have, good or bad. And remember, you don't make the facts, you don't make the case. This is not your problem in that sense. Don't make the client's problem your problem. You can't control the fact that a terrible case landed in your desk, just like you can't control the fact that a great case landed in your desk. Don't take any more credit for that than beating yourself up for a bad case. It is what it is, and the circumstances are what they are. And the sooner you can figure out what they are and really be able to explain to the client, that's what they're paying you for. They're paying you for your advice. They're in a situation and they want you to fix it. They want you to make things better. And sometimes making things better is paying the policy limits. And sometimes making things better is winning a trial. And sometimes making things better is winning on summary judgment. It depends on what the situation is. A win is defined differently in each case. And it is up to you, in conjunction with the client and your supervising lawyer, to figure out and define a win for your case and for your client in your set of circumstances. And so that's why initial evaluation is so important. That's why sitting down and figuring everything there is in case is so important. Generally, that first bill to the client, typically a big bill, and you need to explain to the client everything you're doing and get their buy-in and explain to them why you're doing what you're doing. Because you may create this great work product, a great valuation letter, you may have spoken to all these witnesses and secured all these documents, but suddenly there's a huge invoice going their way and they're not expecting it. And so that's why it's so important to keep the client apprised of everything you're doing and make sure you have approval for everything you're doing. Because doing a great job isn't enough. Doing a great job and meeting the client's expectations and meeting their price point, that's what's really important. And so let's shift briefly now into the world of billing, which is something that we're all going to have to do as civil defense lawyers. Many civil defense lawyers consider the bane of their existence. And there are a number of lawyers who have left the practice or switched to the other side or gone in-house just to avoid billing altogether. They find it to be a huge pain in the neck. But billing is really important. And what you do when you bill is that you're telling a story. And I'm going to give you some sort of rules of the road when it comes to billing your cases. Let's say you get an automobile accident case and you have to bill monthly on that case. You're going to be doing a number of things in that case. You're going to be interviewing witnesses, you're going to be securing documents, you're going to possibly go out to the accident scene, you're going to be serving discovery, you may be doing some research about comparative fault, and there's a whole host of things. Before you start doing any of that, obviously, you want to come up with a plan for the case. You have to decide for yourself, well, what do I need to do for this case? And then you're going to tell the story of that case through your billing. We're going to make sure that all your entries lead to the ultimate resolution of that case. And it shows the client that you're basically doing things that are necessary to resolve the case. You're not just billing the sake of billing. You're not engaging in activities just to add a 0.1 or 0.5 here and there. You are actually doing things that are productive, constructive, and that aid in the resolution on the terms that are favorable to your client. And so when you bill anything, make sure it's descriptive, make sure you add plenty of detail, make sure that it is understandable what you're billing. If you are speaking with someone, include their name, explain why you spoke to him or her, and even explain the purpose of that conversation and the larger strategy of the case. For purposes of emotion, it's not only say prepare so-and-so motion, but explain why you're preparing the motion. Now, this is a sort of trick of the trade. Let's say you're doing something that is very large and substantive, a motion for summary judgment, for example. It's not unheard of to spend several days working on such a motion if the case is large enough. You have to review deposition transcripts, you have to prepare declarations or affidavits, you have to compile exhibits, you have to prepare a complex fact section, you have to do research, you have to prepare the argument section, then you have to draft and redraft. You can see how this can become a very large assignment. What you do not want to do, if you're to tackle a project like that, say prepare motion for summary judgment, 8 hours, 8 hours, 8 hours. That time's going to get cut and reduced drastically. What you want to do is break it down into increments. And my rule of thumb is that unless it's a deposition that's taking all day or a hearing, any other project can be broken down into smaller increments. And the smaller, typically, the better. And not to overdo it and not to turn everything into a 0.1 or to a 0.2, but certainly for a summary judgment motion, I would break it down in terms of reviewing transcripts and naming which ones and why. I would name individual declarations or affidavits I prepared. If I was doing research, I would research. Often it's not just one topic or issue, you're researching a whole host or panoplia of issues. So break those down and explain why each of those issues is relevant for the summary judgment motion. Break down the individual sections of the summary judgment motion. Sometimes something like the procedural section, even if it's a case that's been going on for a very long time, it can take a long time to go back and figure out what happened. The fact section can be very complex. Most people don't appreciate that. But sometimes the fact section is much more important than the argument section because you're trying to show there's no legitimate issue of fact. And so you have to kind of thread the needle and tell the judge, look, I understand this is typical. You're taking this case away from the jury, but this is falls within the four corners of what you do. And I'm asking you to grant the summary judgment motion. So the fact section can take a long time. So that's one way of doing it. And again, remember that the clients review the bills and they don't mind paying a large bill if they were expecting it. And again, that goes back to communicating with the client as to what you're doing. And two, the bill makes sense. Everything in the bill leads to the resolution they're seeking that they agreed to early on with you. And cases evolve, they change. And at any given point, you may end up changing your plan for a case and how you go about resolving the case. But as long as you are working within the parameters of the case, as you set it out for the client, most clients, not everyone, but most clients will understand. Most clients will appreciate that they agreed to this program and protocol, that they signed off on it. Nobody likes paying legal bills. No one likes taking a legal bill and having to pay for it. I wouldn't either. But they get it and they understand why it's important and they'll do it if it's something they've agreed to and it makes sense to them. And also remember that there's these things called pre-bills or pro formas that your supervising attorney will have to review at the end of the month. Now, most clients bill from first day to the last day of the month. Our firm does a little bit differently. Our firm cuts off billing about a week before the end of the month so that we can actually get our bills out in final form at the end of the month and have it on our client's desk before they get other bills. And that's always worked for us. But irrespective of how your firm handles it, keep in mind that somebody else is going to review the bills. Now, as managing partner in my firm, I review a lot of bills. I've reviewed a lot of bills over the years. And these are some of the things I've caught and noticed that need to be improved upon. One, make sure you have enough description. Two, you provide explanation as to entries. Three, if you're going to spend a long time on a project, break it down into individual actions or activities. So it doesn't seem as if you're spending the entire day in the library just spinning your wheels and not accomplishing a whole lot. Four, you really want to tell a story. My first job was at a firm called Hinshaw & Culbertson. It's a national litigation firm based out of Chicago. It's a great firm. And one of my supervising attorneys by the name of Sam Holland, who's since retired now, told me that if I ever want to learn about a case, don't go to correspondence files. This is back day when we had hard copies of files and everything, the file room, pull a case. I said, don't pull the correspondence file, pull the billing file, because that will tell you what's really going on in the case. If the lawyer knows what he's doing, he's telling the story to his client, and then you'll be able to understand the story of the case by really reading the billing file. And I've always taken that to heart. And I always tell folks, and you should tell others, and you should certainly abide by that what you're trying to do is you're telling a story. By the way, billing is sort of an art form. It takes time. I suggest that you read the bills from other lawyers at your firm, ask for copies of bills that actually have gone out. You may actually want to see bills that were pre and post revised to see what changes are made and what things certain partners didn't like or they particularly were annoyed by. And remember, as I mentioned, we're going to be reviewing the bills at the end of the month. If we review the bill and we hardly have to make any changes to those bills, we love you so much. I mean, this is the best thing you can do for a partner. The last thing a partner wants to do is review a long and tedious bill and have to make a bunch of corrections on it and revise and revise. That is not a happy day. I know a lot of partners complain bitterly. It's something that they do on the weekends, and it's typically something to do, I guess, the first weekend every month, and they're not particularly happy about it. So make their lives easier and they will appreciate it. A skill that you can bring to the table is good billing and good billing practices. I've given you some tips, but again, review the billing that have gone out to your clients from your firm, and that will give you a better sense of what your clients expect. And different clients have different expectations. Read your clients' billing guidelines and billing requirements. Some expect very detailed billing requirements, some a little less so, some want block billing, some don't. And different clients have different things. A lot of clients now require codes, and they do that to determine and study, what different firms are billing on and compare one firm to the other and have different analytics about how much work is going into a different part of a case and so forth. Keep that all in mind when you're billing. Now, I mentioned earlier about investigating everybody involved in the case. Some lawyers take different perspectives on this, but I think that's very important because the most important people in your case are going to be your client, the opposing party, the opposing counsel, and your judge. And so you really have to get to know all of them on their terms. With regard to your client, if you're representing a corporate client, take the time and look at their website. Take a look, just as you studied your firm's website and your mission and your vision and your values, do the same for your client's website. Get to know them, get to know their business model, get to know what motivates them, what they do and how they do it. It's probably not really billable per se and something you have to do in your own time, but getting to know your clients and speaking to them on their terms is very important. I remember an attorney, Douglas Burrell, who is one of our members in the FDCC, says a fascinating story. And his story was about how he had a client, and the client, I think, had some sort of pyramid or value system that they kept in all their offices. And every office he went to, they had like this diagram of who they were and what they did and what their values were. And he asked for a copy of that. And he not only took it and put it in his office, but he made sure that all their associates had it in their offices. And the client visited one day and noticed this brochure, this form on the walls of their other attorneys' offices, which was the same that was in his own home office back from wherever they were from. And it was really moving and touching. And he understood that the lawyers understood him, that they wanted to work on his terms and they wanted to handle their matters the way he wanted his own company run. And so kind of keep that in mind. So really understand, get to know your client's business. The second person you need to get to know is the other side. If it's a company or corporation, you have to know how they operate. If it's an individual, learn everything you can about them. Get all their social media posts. Make sure that you ask them to preserve all their social media posts. By the way, we live in this sort of society where there are no longer any secrets. And a lot of that is on our own. We've kind of turned over any privacy rights and thrown those out the window quite some time ago. And so there's very little that we can't learn about a plaintiff in a case. Between Facebook and Instagram and Twitter and LinkedIn and a whole host of other platforms, people are constantly posting and sharing and oversharing, and all that information is out there. So make sure In your first request for production interrogatories, you ask for that information and you try to find out everything you can. You try to get all the information about prior lawsuits, about prior bankruptcies, about anything else that is out there, and try to get all that information, because that'll paint a picture of who you're dealing with. It'll make you understand the type of person who's on the other side, whether they're likely to be truthful or not, likely to say more than they should, get a sense of what their damages are, what their injuries may be. This is all very important. Third, get to know your opposing counsel. Some opposing counsel are very good trial lawyers, some are not. Some are good litigators, some are not. Some are thoughtful, some are not. Some are smart, and some are not. And some are going to be on top of your case, and some won't. And some, this will be the most important case for them, and for some, it'll be just one of another 100 files or 10. And it's important to know that because that will sort of dictate how you handle the case. Different lawyers, that's going to affect your evaluation of the case. It's going to affect issues of liability. It's going to affect how you prepare your client for deposition. It's going to affect what witnesses you interview and what documents you seek and what motions you file and how you set the trajectory of your matter. Your opponent is very important, and knowing your opponent, just like if you were to play a tennis match, you want to know what your opponent's strengths or weaknesses are. If you're certainly in a boxing match, you want to know how they punch and what side they favor, and how close they get and how defensive or offensive they are. This is no different. So get to know your opposing counsel, and certainly at the end, get to know your judge. Get to know how she rules, how liberal or conservative, how much she favors plaintiff or defense. What her background is, whether she worked for a plaintiff or defense firm or whether she was at a criminal court, how much she's familiar with civil matters. Some judges end up going from the state attorney's office to the judge and then practice in criminal court and then suddenly get transferred to civil, and you're one of their first cases and you're learning on the fly, and you know much more about the law than they do because just the set of circumstances they find themselves in. So get to know the judge, get to know their proclivities, how they rule, what issues they may have. You may want to pull some of their old cases that are relevant to your case. If you're handling type of personal injury case, especially one that's heavy with experts. You want to see how they've dealt with experts in the past, whether they've struck or limited expert opinions. There are a whole host of issues, but you're trying to figure out all the players and their vantage point, perspective, and their prism through which they're seeing your case and seeing themselves, because that will help you decide what to do and how you evaluate the case and how the strength of your case is. I have a perfect example. I had a case where it was a personal injury matter. And now these days under Westlaw Edge, they have this ability to find out all the ways your judge has ruled. Like you can determine all the motions they filed and or ruled upon and how they ruled. And so this specific judge had ruled on 500 motions for summary judgments, and she had only granted 3 of them, and only denied like a couple of them. Like basically most of the motions had just sat there, like they had been brought to her attention and she just never ruled on them. It was really quite unusual. And so I realized that it wasn't just getting motions denied. The motions probably was going to be heard and never get ruled upon. Because, let's be honest, if you don't rule on a motion, you can't get overturned by the appellate court. So eventually the case is either going to settle or go to trial, and most cases settle, so just sit on it. And opposing counsel didn't really appreciate that. They were kind of a newish lawyer. But I realized this was, I filed a summary judgment motion, but I realized it was never going to get granted. It's never going to get ruled on. And my client had to appreciate that and understand, look, either we settle this case now or we're going to have to try this case. Because even though the case is very favorable to us on the law and on the facts, unless we actually try to settle up mediation or something more informal, the judge is not going to rule on her motion. If she does, she's going to deny it. She just doesn't want to be overturned. And that helped us deal with the case. We ended up paying a little bit more than we wanted to pay for the case that it was, but a lot less than we would have paid if we'd have let things drag out. And so knowing your judge is important. Now, certain judges are very strong judges. They grant a lot of motions for summary judgment. That's good to know too. There are certain judges that have a defense background and believe that most plaintiffs' lawyers are faking. Hey, that's important to know. Each of us come to our practice, come to the bench, come to a case with our own proclivities, with our own biases and opinions and prejudices. And you should know, you should really get to know that. And so once you got to know your case, the facts and law, got to know the players and the parties, then it's time to sit down and define what a win is. And a win means different things to different people. I alluded to this earlier. And a win could be paying a lot, or a win could be getting out of the case early, or a win could be getting the case dismissed on a motion to dismiss or summary judgment. It depends on the case. And it's important to bring your client in early and help with them and figure out exactly what a win means to them. Now, it's very case dependent. There's no other way of saying it. Some cases you can resolve for pennies on the dollar. Some cases may just require a strongly worded letter. Some cases may have to be taken to trial. And that's going to be part of your analysis and part of your evaluation, but the client needs to appreciate what's going on. And I think the client and you both need to understand, like, first of all, you didn't create the situation. Sometimes, a lot of times the client didn't either, just things happen. But you have to deal with it. You've been sued. There's a lawsuit. There's a complaint you have to answer or respond to. There's discovery you have to respond to. There's depositions that have to be taken. There's witnesses that have to be prepped. It is what it is. And so, we can complain and bicker and argue that our legal system is broken and that there are way too many lawsuits and why are people allowed to sue for anything? But they do. I can't control that. The client can't control that. The best you can do is help the client through that morass and through that obstacle course, and do whatever you can to help them understand the strengths and weaknesses of their case and maximizing their strengths and diminishing their weaknesses. And once you have a plan, and I literally mean a plan, like sitting down and thinking through, is this a case we win on summary judgment? If so, how? Is this a case we win on a motion to dismiss? If so, how? Is this a case where there's just way too many facts involved and we're going to have to pay? And so it'd be nice if we paid between X and Y or between A and B. Once you have that as sort of the end game, sort of keeping the end in mind, how do you get there? And coming up with a detailed plan, step by step, in terms of what discovery to propound, what interrogatories, request production to serve, what depositions to take, which witnesses to interview, what documents procure, literally spelling out what you need to do to get from here to there, to get from A to Z, and to win the case on your terms. And sometimes they're not really your terms per se. I mean, your terms would be you want to settle a case for a lot less or get it resolved on summary judgment. But winning the case on terms that your client understands and agrees with, that's what's most important. And once you have the case, then you just work through the case. Then, you have a plan. You basically have created a checklist for yourself of all the things you need to do to achieve your goals. And then you work through them. And cases are much easier to deal with if you know where you're going. Because that way you can always hold up a project or assignment or task up to the prism of your case plan to decide, well, does this fit within the strategic plan or doesn't it? If it fits, I'll probably do it. If it doesn't, I'm not. And it just makes a whole lot of sense. And I think supervising lawyers, the good ones, they come up with a plan early, they settle on a plan, they get the client's buy-in, and then everything they do in the case works toward that plan. And if it doesn't help the plan, doesn't help achieve the objective, they don't do it. And that's true for life. That's true for, if you're gonna start your own business, it's true for just about anything. And it's certainly true for how you handle your cases. And so you're going along, you're working your case, and something happens, something you weren't expecting. You have, let's do a few examples. Let's say, for example, you have opposing counsel who is being particularly obnoxious, trying to take advantage of your inexperience or the fact that you haven't been handling that many cases, and they feel like, they smell blood in the water. When that happens, I really recommend you get involved. Get your supervising attorney involved as early as possible, and you make them aware of what's going on. At this stage of my career, that doesn't happen to me anymore, but it does happen to my associates. And I have to intervene and tell the other attorney who I typically know, look, I know what you're up to. I wouldn't do this to your associate, don't do this to mine, and tell them to quit it. But it's going to happen. People are going to try to take advantage of your situation. Obviously, deal with it as best as you can, but don't. But get your supervising attorney involved. Don't feel like you are running to mom or dad. It is what it is. If there is an attorney that's being unethical or is misconstruing what you're saying, certainly get your supervising attorney involved. Remember that everything you put in an email or in correspondence can be attached to emotion. Remember that anything you say to opposing counsel may be reiterated to a judge. And so keep your cool, remain professional. Some attorneys are trying to goad or bait you to get you to say or do certain things so that they then turn around and run to the judge and say, aha, look, this attorney said this or said that. And suddenly that judge is like, wow, that's really unprofessional in an attorney. Why is he saying or doing or writing that? And so that's part of the game, unfortunately. And so certainly just for professional reasons, you should always keep your cool. But remember that there are wolves in sheep's clothing and lions lying in wait to try to get you to trip you up and get you to say something you shouldn't. So always be aware of that. And then keep in mind your clients. Sometimes clients ask you to do things you shouldn't. Sometimes they want to destroy documents or kind of keep things from you or asking you to keep things from opposing side or may make certain misrepresentations. Again, things like that, you got to talk to the supervising attorney. You have your reputation, you only have one, you have one license, you only have one, and you're not going to sacrifice either for a case or a client or just to win. I've seen too many lawyers in my career do anything and everything to win a case because of their reputations. They want to be known as a winner, or because they had some payday that they're waiting for and they were willing to do anything to get that big verdict or settlement or get that defense verdict. And so remember that, we all have rules of professional conduct, and each state has their own. And I recommend, just like you should read your firm's website once a year, you should read the rules of professional conduct once a year. And in fact, let me digress for a moment and go through what you should be reading as a young lawyer. Once a year, you should read the content of your firm's website in terms of its mission, vision, and values. Once a year, you should read the rules of professional conduct. They change periodically, especially the rules dealing with advertising and marketing online. We all have a presence online, and it's important to kind of keep that in mind. Read the civil rules of procedure, both state and federal, once a year, and read the rules of evidence, state and federal, once a year. They change, not that much, but they do change, and you kind of forget what those are. And if you have an active civil practice, and you certainly can try cases, if you forget a rule when you're in a cross-examination or direct, that can hurt you. So, just make that a practice. You can read them on your phone. You don't have to read it all at once. You can read them while you're waiting in line at the supermarket, or you're waiting for a hearing or deposition to start. Just kind of read through them. You don't have to read through all the comments, but certainly read through the rules. Also, become acquainted with any sort of handbooks your state professional bar or your local defense bar puts out. The state of Florida has a professionalism manual, which is very good. It kind of goes through all the rules of professionalism and also provides do's and don'ts in terms of deposition practices, litigation, discovery, written discovery, all that. Florida also has a discovery handbook. They update every few years, and the last one was 2019. Your state may have one as well, where they kind of go through all the case law relevant for various discovery issues. And often if I have to file or draft a discovery motion, I'll go there first because all the research is done for me. I can cut and paste it, and it's considered sort of an authoritative source in Florida. And so not only do I cite the underlying cases, I often cite that manual. It was a manual that's written by conjunction of both judges and lawyers. It's updated periodically, and it's a great resource. There's a whole chapter on e-discovery. There's chapters on independent medical examinations. And again, there are resources available. Certain federal court districts have similar manuals or guidelines. Get to know what those are and take the time to read those and get to know those. In addition to those books, get yourself a good grammar book. Strunk and Wright has a great book. There are a bunch of great books on grammar. You're probably saying, well, grammar, really? You have to read a book on grammar? You'd be surprised how many rules of grammar we've forgotten. We typically learned it in middle school and high school, and then we never learned it again. And, bad grammar really undervalues and hurts your writing. So take and in addition to grammar, get a book or two on effective writing, effective legal writing, or just writing, business writing, just effective writing. And I think writing is predominantly verbs. It's 50% verbs, 30% nouns, and 20% the rest. And what I mean by that is that if you want to write effectively and communicate effectively, think first in the active voice and use active specific verbs. Use very specific nouns. If you use noun, verb, object of the verb, which is a very basic form of sentence you probably learned when you were 8 or 9 years old, and you kind of use that as sort of your lodestar, your writing will become more concise, more precise, and more active and more empowering. Remember, it is noun, verb, specific noun, active verb. Every sentence you write, unless you're specifically choosing to do otherwise, should use an active verb. Every noun you use should be a very specific noun. Try to use very few adjectives and hardly any adverbs. Try to reduce the prepositional phrases you use. And what you'll find is that you'll communicate in a much more effective, direct way. I think we as lawyers learn to obfuscate a little bit too much. We try to have it both ways. On the one hand, this, and the other hand, that, because we don't want to take a position, because we don't want to commit, because we don't want to tell the client one thing and then it turns out to be another thing. It's kind of wishy-washy, and you can't let your writing be that way. And you can't let your communications be that way. And so in your library of books, make sure you have something on writing, both in terms of grammar and writing itself. And then get some books on skill sets. You know, there are lots of books out there, and you're certainly welcome to download mine. Most of them are free, but they're books on deposition skills, trial skills, interviewing skills, voir dire skills, discovery skills, you know, DRI, FDCC, so many organizations out there both put free books. If there's something that you think it's worth investing, maybe ask your firm, maybe pay for it yourself, ask around, maybe even create like a book club where you and half dozen other young lawyers agree that each of you will buy, you know, a leading treatise or volume or book on a specific trial skill or pre-trial skill, so that none of you are spending too much money on these books, and then every month you swap a book. So that's something where I'd recommend you do. And then ultimately, in terms of writing, reading, I should say, read books on leadership, read books on marketing, read books on sales, on business, because you are as much of a business person as you are a lawyer. And it's not something you learned or probably expected or appreciated, but successful lawyers are good business people. Successful lawyers attract and build their own books of business. And if you want to be in this practice for 30, 40 years or more, in order to be truly successful, you're going to have to attract and keep clients. And in order to do that, you have to understand how clients think, what they want, how they want you to communicate with them, how to carry yourself. Certainly, all you need to have all the hard skills. You want to be able to put out great and superior work product. But there are a lot of great lawyers out there who have very few clients. There are lots of great lawyers out there who've never developed a huge book of business, and that's because they've never really learned or maybe haven't trusted themselves to put themselves out there and develop relationships that lead to business. So read books on leadership, read books on marketing, read books on business, on sales, because all those books will talk to you about skills that you probably never even learned, maybe were even aware of when you're in law school. So, you know, think about that and do those things. And I mentioned something earlier about leadership and, you know, how clients perceive you. There's a word that an attorney I know, Tim Pratt, who's a member of the FDCC, likes to use. It's called gravitas. And being able to hold and own your space is very important as a lawyer. Young or old, male, female, whatever ethnic background you are, being confident, owning your space is very important. Clients love that, because at some day you're going to have to convince the other side to pay less. You're going to have to convince a judge to agree with you on a motion. You're going to have to convince a jury to rule in your favor. And you do that with confidence. No one's going to side with you if you're not confident, if you do not have that gravitas. And Tim tells me a story, which is a great story. He says, you know, go to the lobby of any large building, any large office building, and see people walking by. And immediately, by the way they carry themselves, you will know if they are a leader or not a leader. And what he meant by that is that our body language reveals and says so much about who we are. You know, you can tell somebody's a leader by the fact that they hold their shoulders out, they're looking up and straight ahead, they're taking large steps, they're owning their space, they're smiling but not too much, they're keep and maintain eye contact, they have firm handshakes, they take up a lot of space with their bodies, both their arms and their legs. They're basically conveying to the world, I got this. I got this, and you're with me, so we got this. We have this. And if you feel, and it's tough for a young lawyer, by the way, because you just get out of law school, you're starting out, you're constantly trying to be taken advantage of, your judges are looking down at you, your clients are wondering why they're paying you so much for so little experience. There's a lot of imposter syndrome. There's a lot of issues about who you are. But the faster you can build your confidence, the better. The faster you can get from feeling afraid to feeling confident, from feeling concerned, from feeling self-assured. That is the most important skill to have as a lawyer. And it's really hard to teach, but I would suggest that you do a few things. And I understand you already have a full plate, you're working a lot of hours, doing a lot of other things, but this will really propel your career. One, I would ask that you suggest or recommend you join Toastmasters or something like Toastmasters, where you're meeting on a regular basis. I think they meet weekly, where you practice your presentation skills. Getting accustomed and used to speaking in front of a group of people and just communicating is the most important skill set you ever have. Even if you don't try cases, even if you're not a trial lawyer, even if you're a transactional lawyer, I don't care. But being able to hold a room, hold a person's attention, being able to communicate, being able to have them listen to you, very effective, very important. Toastmasters is one. I took improv a few classes over the years, and I'm waiting for COVID to die down to go back and do it some more. Improv is one of the best things you can do. It costs about $250, $300 for an 8-week to 10-week class. Is a lot of money? Yeah, it's a lot of money. For a young lawyer, it is worth the investment. You go to a class, you get together with about a dozen other students and a teacher, and you do some wacky and crazy things, and you learn to think on your feet, and you learn that it's okay to fall down, to say something dumb, and not to be that funny or that clever. And you realize the world doesn't come to the end. You don't get sucked up by the ground, and you're fine. You know, life, in order to get good at life, you have to suck at it for a while. You have to suck at it for a long time. To digress and to permit a digression, I've written about 20 books, about 400 articles. My first 2 articles, they sucked. My first book, not so good. I've spoken now a lot. I've kind of lost track. My first few presentations, I wanted to throw up on myself. It was hard to even look at the audience. I couldn't maintain eye contact. I couldn't even remember what I was saying. I had to have it all written down. I mean, it was horrible. It was just terrible. My first few articles, not good. It just, whatever you do takes practice, and you have to put yourself out there. And the first few times you do it, you're not going to be great at it. At best, you'll be okay at it. And that's fine. That's perfectly fine. And so find a friendly environment, write a small piece, maybe blog, whatever you can. You got to play in Peoria before you're playing at the Lincoln Center. But it's a process. And your first depositions are probably going to suck. Your first hearings are probably going to suck. Your first status letters are going to suck. Okay, so what? That's how you get better at it. And then hopefully you're at a firm that supports you, understands that, appreciates that, and will work with you to develop you and make you better. Who you are on day one is not going to be who you are at the end of the first year, 10 years, at the end of your career. It is a process, it's a lifelong process. I'm still learning a lot. A lot of what I do, by the way, a lot of speaking and writing, is predominantly for myself. I wrote a book in 2019, The Practice and Process of Law, which is a book of checklists. It's basically, I took everything I do in my practice, I turned into a checklist. And I did it because I guess I realized informally and subconsciously, I kind of had these mental checklists, but never had reduced them to writing. And I thought, well, it's probably a good time to sit down and reduce everything I do, and literally mean everything. I mean, low OCD on my part, but literally everything I do into a checklist. And I thought it was well received. I got some good reviews and sold a lot of copies. It's one of the few books, maybe the only book I've sold. All of my other ones are free. But it helped me focus on what needed to be done. And so 23 years out, I'm still learning. I'm still evaluating. I'm still trying to figure out how to improve myself. And so if you're just coming out of school now, or you've only been out for a couple of years, it's okay. You're never gonna stop learning. And as long as you embrace that, embrace the process, and kind of think of it sort of like Thomas Edison. He had to make 10,000 experiments that all failed before he figured out the light bulb. If he had stopped at 9,999, he wouldn't have a light bulb. So this is no different. And will you annoy some people along the way? Sure. Will some clients not maybe get disappointed? Maybe a partner may get disappointed. Yeah, it's probably going to happen. But it is what it is. Trying to play it safe. I've done that. I did that a large part of my life. Wow, it's not a good way to live. Like trying to protect the lead, trying to do what's safe, trying to do the easy things. That's hard to do. That's not that easy to do. And so, these are things that you need to figure out for yourself, but you certainly have to undergo that process. And so that's part of what we're doing. It's talking about the associate's life. The associate's life is not an easy life. You're kind of living or working two jobs. One job is your day job, where you're billing hours, where you're working cases, where you're learning the practice. And then there's this night and weekend job, which I hate to tell you, but it's equally as important, where you are taking time to learn the practice on your own. You are maybe watching CLE online, which, by the way, there's so much free CLE these days through COVID. You're reading the rules I suggested you read. You're reading the books I'm suggesting you read. Maybe you're taking transcripts home with you or pulling them up on your computer of hearings and depositions or even trials to see what others done and why they did them. And you're really taking the time to learn. The learning curve that first year is really steep, and you're gonna make your share of mistakes. And that's really the highest level of anxiety, I think, that first 12 months, 18 months, where you realize you don't really know that much. You know the law, but you don't know the practice. You're dealing with lawyers who are much more experienced. You're running to your supervising attorney more than you think you should be running to them too. And periodically they're getting a little annoyed, frustrated with you because that's what senior lawyers do. I hate to tell you, but that's just the way it is. And it's stressful. There's no other way of putting it. But you'll figure it out. We all did. We all figured it out. And there'll come to the point where you'll be in my shoes and you'll be recording videos like this and helping younger lawyers and telling them it's going to be fine just the way I'm telling you it's going to be fine. It's all going to be good. So one other thing, or a few other things before we close out. One thing is personal marketing or development. Now, if you're a young lawyer, you're probably not even thinking about that. Maybe you're not thinking, well, me develop clients. I mean, I'm just out, or I've only been out a year or two. But early on, you want to prepare your own personal strategic plan with your own marketing plan that kind of spells out for you what you plan on doing over the next 12 months to get your name out there and to develop a niche or an expertise, to either write or to speak, to get a leadership position, to do one or more things where you expand, you grow your reputation, you expand your footprint in the community, you expand what other people know and like about you, and you start developing relationships. Business development is all about relationships. People who know and like you refer you business. And so you need to start thinking early on what you could be doing to do just that, to be developing business. So prepare a strategic marketing plan. If you want to find a type of plan you can use, go to my website. And I haven't mentioned it yet, but I have a website called miamimentor.com. And on that website, there's a list of books, one of which is Attorney Marketing 101. It's actually an FDCC publication I wrote. John Remsen, who is a marketing guru for law firms, and he actually spoke with our firm a number of years ago and helped us a lot. And actually, the marketing plan in that book is the one we use and the one he uses and recommends. And so I recommend you take a look at it. It kind of spells out all the do's and don'ts and what you can and can't do, and the things you should be considering and thinking about, even in your early stages of the career. And it's also another way, by the way, to sort of set yourself apart from other lawyers. If you are serious about your career and you're doing things early on to sort of set yourself apart and seek out and pursue leadership roles, you're speaking, you're writing, you're blogging, you're doing all these things that ultimately are going to lead to business, your firm will take notice. They will see you as a superstar and they will want to keep you. So going beyond just doing good and great work and going beyond communicating and making sure your bills are right and abiding by all the do's and don'ts and pet peeves of all your lawyers, going that extra mile and starting to lay the foundation for a book of business is something firms pay attention to, because firms live and die by their clients, by the cases they get, and if there aren't any cases coming to the doors, lights are going to stay on very long. So if you can be part of that solution, then they'll certainly appreciate you for it. And in terms of case handling, in terms of your typical day, your firm, you're handling your cases, time keeping is important. Being able to control your calendar is important. Make sure everything gets on your calendar immediately. Make sure everything is properly calendared. Make sure you look at your calendar regularly. Every morning I look at my calendar, not only for the day, but for the entire month. You think it takes long? It does not. I can probably look at a month's worth of calendar in about a minute or 90 seconds based on all the practice I have. So get used to doing that. Get used to looking at your calendar and making sure nothing surprises you. For example, if you have discovery coming up, you don't want to find out that it's due tomorrow. You want to know it's due in 3 weeks. If you have a motion coming up, you don't want to find out the hearing's tomorrow, you want to know what to do, it's a month from now, so you have time to gather affidavits. You have a deposition coming up, you don't want to find out tomorrow, you want to find out a month from now in case you need to get additional records. So you really need to be on top of your calendar. That's very important. I think the difference between mediocre and okay associates and great associates are ones who manage your calendar effectively. And there's still a lot of lawyers, senior lawyers, who are just terrible at managing their calendars. I don't know how they make it through life. And again, mentioning my OCD again, I mean, I look at my calendar not only 30 days out, but sometimes 60, 90 days out. Nothing surprises me, or remotely surprises me. I mean, I am not a person who's ever surprised, because I know my calendar intimately, and that's something you need to know. And make sure that things are ending up on your calendar. Like if you ask your legal assistant to put something in your calendar, make sure it's there, because it's your responsibility. Don't blame your legal assistant or your paralegal for your cases. Everything that happens in your cases are your responsibility. The buck stops with you. And if something in your calendar, yeah, okay, set it up. But guess what? You should have made sure it got in the calendar. Something didn't go out that the paralegal said it was going to go out, some subpoena. Yeah, he or she screwed up. But guess what? You should stay on top of them. You're responsible for the case. Do not pass the buck. You are responsible for your cases. And in terms of time management, that's important, obviously, making sure that you're not always reacting, that you're not letting the urgent take over the important, as they say, and the 7 habits of highly effective people. You want to make sure you're doing the important things and that you're not just reacting to things, you're handling emergencies. And I have a couple of suggestions. One, get in the office earlier. Yeah, I know that sucks, but it works. 2, keep a to-do list and keep track of it. 3, keep a case list, and make 2 columns. On the left, put all your cases and whatever case numbers there are. And on the right, keep a list of to-dos for those cases. And that way you know that you're staying on top of things. And commit to doing things proactively. Like there are certain days that you're just reacting. And that's true whether you're on the plaintiff or defense side. But no matter how reactive you are on any given day, do something that's proactive. Serve some discovery, interview a witness, do a proposal for settlement, do something that you're pushing the case on your terms and not on the terms of the other side. And that's an important thing to understand as the defense side. So many defense lawyers think, well, I'm the defendant. I don't really have to do much in this case. I'm just gonna, they file discovery, I'll respond, I'll source some discovery, they take a deposition, I'll take a deposition. I'll let them set for mediation. I'll let them know it's the case for trial. I'll let them prepare the case management conference in order and everything else. And I just, if they're not pushing it, why should I push it? They're not interested, and client doesn't want to spend money, and that's not the right approach. And there are clients, by the way, who don't want you doing anything, and that's their prerogative. That's fine. But I found that most clients want you to take hold of the reins of your case, dictate the case, determine where the case is going, what is happening in the case. You're the one deciding what motions are filed, what witnesses are being interviewed and being deposed, what conferences are being held, when the case is being set for trial, the pretrial conference and scheduling order, and what the deadlines are. I mean, you're the one in the driver's seat, and you're the ones dictating that. And if you can dictate the case and set the rules and set the pace and set the cadence, you can ultimately set the outcome in the resolution. Not always, but it really helps. And so when you look at your cases, part of it's gonna be reactionary. You're gonna be getting assignments from partners and you have to deal with those assignments. But always think through your case and say, what can I be doing to get to that end game, to reach that win, to conclude the case in terms that are favorable to the client? And there's always things you can be doing. There's always witnesses you can interview, documents you can seek, motions you can file, research you can be conducting. There are a plethora of things, obviously with client approval and understanding, but there are a plethora of things you can do to win a case on your client's terms. And so time management's tough. It's very challenging. Even seasoned lawyers have a tough time. But if you are on top of your calendar, making sure things are properly calendared, if you have a case list with a detailed to-do list, and you go and you put items from, let's say, from black to green to red, or whatever color scheme you want, or green, yellow, and red, to know how urgent things are. And some people do that. I don't, but if you want to be that specific, and you make sure that any given day you're dealing with things that have to be dealt with, and they're at the same time you're dealing with things on your terms where you're pushing forward on it, and you learn to juggle all those balls and keep all those plates spinning at the same time. That's what a great lawyer is. A great lawyer is part a great writer and great researcher and great thinker, but a great lawyer is also great with time management. They're great with their calendar, and they also are great just in terms of their personality. They, as I mentioned, they're confident, they have certain gravitas, and they make time to develop business. Now you're thinking, wow, this is a lot of time. It's a lot, you should time commitment. Yeah, it really is. I don't know how to say it. Like just saying all these things out loud to myself, like, wow, this is a lot of work. And you have to be honest with yourself. Like if you're going to succeed in this career and really be on top of your game and really impress your firm and yourself and develop a book of business, it's a big time commitment, and you have to be committed to doing that. And so let's talk a little bit about work-life balance and where that comes out. We have two boys. I'm married. Anna's my wife. She's the executive director of the FPLA. We have two boys, 22, 19, David and Michael. And I have to tell you, I missed out on a lot of things when they were younger. And that was partially poor planning on my part. I think technology has allowed us to do a lot more things remotely and being able to do things much more easily. We don't have to travel as much. And I think I was probably born a little too early for this career, but it was tough. It was tough and challenging. A lot of friends I know I went to law school with since divorce, some are estranged from their kids. Some have committed suicide. Some have ended up in prison for a whole variety of things. Not to bring everybody down, but there are a lot of pitfalls, a lot of challenges, and you have to take care of yourself. So I spelled out everything you need to do to be a great lawyer. But at the end of the day, you need to take care of yourself. You need to watch out for yourself. You need to eat well. You need to diet and exercise. You need to spend time with your spouse and your kids. You need to do all these things. And so when I mentioned calendaring, not only do you need to calendar stuff for your work, but you should calendar stuff for your family. You want to make sure, and I keep a calendar at work, and I probably include too much possibly, but if I'm going somewhere and having dinner with somebody, I'm going to put that down. If I'm going to have dinner with Anna or we're going out, I'm going to put that down. If I'm on vacation, I make sure everybody knows I'm going on vacation, so there's no surprises to anybody. If I'm going to go to an event for the boys, I always had that on my calendar, and I let people know that day, look, I'm going to be out. This is both my boys are into music. I'm going to be at this recital. I'm just not going to be available. And if you're putting in the time, you're putting in quality work, your firm should be reasonable and should understand that. Some firms aren't, and maybe that's a bad sign, but I think most firms have come to terms with, working with their attorneys and have this give and take where the attorneys are making sacrifices and the firms in response to that are allowing them some flexibility in terms of how they handle their workday. So kind of keep that in mind. And, and it's a challenging job. There's really no other way of saying it. But it's fun. It's once you get past the fear and the uncertainty of it, and you come to learn how to practice, you'll still continue to improve. You'll still work on your skill set. I still do that obviously on a day-to-day basis. Even just speaking to you on this video is making me think through various things that I can do better. Having this sort of almost self-discussion with myself is, I think, making me a better lawyer, certainly today and tomorrow. But it's a process, and it is a process that you try to push through as quickly as possible, but at the same time, it remains a process. It is a lifelong process. And no matter how much you improve and how much you better yourself and how many clients you get and how many accolades you receive and how many leadership positions you obtain, it's still a process. You're still learning every day. And it's humbling. It kind of keeps your head from being too big. But that's important. That's really important. So, but make time for yourself. If you feel like things are getting away from you, seek professional help. Stay connected with your family and friends. If you are suffering from depression or anxiety, talk to somebody. And there's always been a stigma to mental health issues, especially in the legal field. There's still some stigma, not as much, but still there. But find somebody. There are lots of resources. Your state bar has resources. Your local bars now have resources. Find somebody to talk to. There's lots of books, there's podcasts, there's videos, all sorts of things. And I guess the last takeaway is to learn how to do everything, which I guess is impossible, but you try to figure out a way to find time for everything. This is your career, and no one is going to watch out for your career but you. And this is your life, and no one's going to care about your life as much as you. And your firm is your firm, and I'm sure they want what's best for you. But at the end of the day, the firm is the firm. and you are you, and you have to worry about your career and your life and your health and your happiness and your well-being and your own joy. And so come up with a strategic plan at the beginning of every year, not just for your work and for your office and for your career in terms of what you want to do, in terms of, let's say, what organizations you want to join or what you want to write or where you want to speak or what expertise or niche practice you want to develop. But, sit down and think, oh, where do we want to vacation this year as a family? What do we want to do as a family? What do we want to achieve as a family? What do I want to do as a personal health? Do I want to lose some weight? Do I want to get ready for a marathon? Do I want to start working out? Do I want to join a gym? Do I want to do martial arts? And then for my own personal mental health, is there a hobby that I've been putting aside for the longest time that I want to pursue? Are there novels I want to read? Is there a trip I want to take? I want to write a book or a novel myself? Because at the end of the day, it's like life's kind of short, and there's more important things than just billing a lot of hours. I mean, that's obviously important. Firms need hours to be billed, but there's a whole other life out there, and so pursue it. The reason I do these videos and I do the website and the books I've written and everything else is that I realize this is a very challenging career, and very few of us have people that we can talk to, and there are very few people who will listen to us. And so I'm hoping that I can be some sort of guidance and help in this time, challenging times, not just for young lawyers, but every lawyer. And I hope you found this video helpful. If you want to reach me, feel free to find me on my firm at mightymentor.com. There's a form you can fill out and send me an email and send you my cell phone. We can talk about whatever you want to talk about. I've spoken with lots of lawyers all over the world, and if I can't talk to you that given day, I'll make time to talk to you soon thereafter. And remember that the practice probably isn't what you expected, but it's still good. It's still challenging. It's fun. It's engaging. And you can certainly use it as a force for good. Clients need you. They want you to represent them. There are things you can do outside of your firm in terms of community service and help and a whole host of things. And the skill sets that you developed in terms of research and writing and speaking and presenting and thinking, those are skills that you can use to make this world a much better place. So go out, do good, and until next time, I'm Frank Ramos. I wish you the best. And again, if you need anything, feel free to reach out to me. Look forward to it.